Afternoon. Thank you for joining us today. My name is John Sherman, and I'm the litigation director at Fair Election Center and lead counsel for the petitioners in Aleman v. Beshear. I'm joined by one of the petitioners, Bonifacio Aleman, who will be speaking as well. I'll be answering questions after all statements, and we can set up separate interviews with the petitioners in this case. This case began 5 years ago with 8 plaintiffs. It's so old now, 5 years later, that it's about to enter its third gubernatorial term in Kentucky. We initially filed suit against Governor Matt Bevin. We've been litigating it through the first term of Governor Beshear. And Governor Beshear, of course, was just reelected to a second term, and that's about to start. After 4.5 years of litigation, 2 dismissals, 2 trips up on appeal to the Sixth Circuit, we have now reached the U.S. Supreme Court. Today, we filed a petition for a writ of certiorari at the U.S. Supreme Court, a cert petition. We have challenged Kentucky's arbitrary system of voting rights restoration for people with felony convictions. We've challenged this on First Amendment grounds, and this is based on a long-standing 85-year-old doctrine under the First Amendment that the U.S. Supreme Court first developed in 1938, before World War II, and it's been consistently upheld since then. And it basically says you cannot give a government official complete, limitless power to grant or deny licenses to engage in a First Amendment protected right of political expression or expressive conduct. Our view has always been that voting is expressive conduct. Voting is expressive conduct. It clearly is expressive conduct. And for that reason, it's protected by the First Amendment and cannot be subjected to an arbitrary licensing scheme. Folks like Bonifacio, who has done this, have to apply, submit an application to the governor, and the governor has complete and unfettered power to grant or deny that application. There are no rules, no criteria whatsoever. There are also no reasonable, definite time limits by which the governor needs to make a decision. And as you'll hear from Mr. Aleman, he's had a pending application for close to 2 years, or over 2 years at this point. The easiest way to describe what we're challenging in Kentucky is actually to make you think of an opposite, another fictitious sort of scheme where eligible voters would have to petition, where the government would basically mete out the right to vote on an arbitrary basis, right? That would be clearly unconstitutional if government officials were arbitrarily handing out a right to vote. No one would dispute that that's unconstitutional. Think of a system where non-citizens or 17-year-olds who are not eligible to vote could apply to gain the right to vote, and government officials would arbitrarily hand out that right to vote. That is clearly a violation of the First Amendment. Here, we have essentially the same system. We have one government official sitting in judgment of applicants who apply to regain the right to vote. And that's why we've challenged it on First Amendment grounds. So far, the courts have not been receptive to this argument. We did initially in a prior case, my organization, Fair Election Center, had success with this argument in district court in Florida. That case became moot on appeal after Amendment 4 was adopted in Florida. But we've been litigating this case in other states, including Kentucky and Virginia. And the Kentucky case is about to hit the U.S. Supreme Court. The Virginia case just survived a motion to dismiss. So the fight goes on. Today, in the Kentucky case, we've filed this petition for cert at the U.S. Supreme Court. The courts, our argument is that Kentucky's discretionary rights restoration system functions as a licensing system. The governor and the district court and the Sixth Circuit, the U.S. Court of Appeals for the Sixth Circuit, have taken the position that this arbitrary rights restoration system is not, in fact, functioning as a licensing system. Unfortunately, though, the Supreme Court has been clear for decades that when there is a First Amendment case, that has to be treated functionally and flexibly with a functional, flexible approach, not in a very formalistic way based on whatever state law happens to label rights restoration. In Kentucky, Kentucky law labels voting rights restoration as a, quote, partial pardon. And that is the basis on which the lower courts have so far rejected this claim. But we think that the U.S. Supreme Court's precedent in this area dictates a different result. And that result is that if there is a similarity, a commonality between rights restoration and licensing, then it has to be treated under the First Amendment doctrine that we've sued under. Right? Here, our position is this quacks like a duck and walks like a duck. It is a duck. This is rights restoration. You can call it whatever you like, but it is functioning as a licensing system in which government officials hand out a right to vote based on their own impressions and subjective assessment of each applicant. Governor Beshear's counsel at oral argument before the Sixth Circuit said that these decisions were being made based on whether Governor Beshear thought the applicant was, quote, worthy of regaining the right to vote. That is a clear violation of the First Amendment rule that prohibits arbitrarily licensing the particular right to political expression or expressive conduct based on a subjective, vague standard like worthiness. Most states in the country have entirely moved on from this issue, it should be said. Most states do not have discretionary, arbitrary restoration of the right to vote anymore. 40 states, including Texas and Georgia, plus DC, all restore voting rights immediately upon the completion of incarceration, parole, and/or probation. Kentucky is one of the last holdouts in the country that forces the disenfranchised to apply for and seek the blessing of a government official in order to regain the right to vote. And one day, whether it happens in this case or another case, I truly believe, I know Bonifacio also truly believes, that this practice of arbitrarily handing out licenses to vote will be struck down as unconstitutional. It's just a matter of time. It so clearly violates the First Amendment doctrine that has been around for almost 100 years, and it so clearly violates the spirit of our constitutional system of democratic government to have one politician arbitrarily handing out and meting out rights to participate in that democracy. So just in these last few states, like Kentucky, like Virginia, these are the last holdouts in the country, and that's where the fight is. And it's not a small number of folks. In Kentucky, it's over 100,000 people who are still disenfranchised after the completion of their sentence. Governor Beshear's 2019 executive order did nothing for people with convictions in another state, such as Mr. Aleman, did nothing for people with federal convictions, and also excluded people with certain Kentucky convictions. Over in Iowa, Governor Kim Reynolds did quite a bit better. And she issued an executive order that restored the right to vote back in 2020 to almost everyone, including people with federal convictions and out-of-state convictions. And who knows, if Governor Beshear had done the same thing, we may not be here today at the U.S. Supreme Court seeking to get the court to hear this case. And Governor Beshear, it should be said, I'll say before I close, Governor Beshear can still end this case even at this late stage. He has just been reelected, and he has an opportunity to extend his 2019 executive order and allow and restore the right to vote to a broader range of people than he did back 4 years ago. So I'll stop there and turn it over to Bonifacio, and I'll be around after these statements to answer questions.
Thank you, John. My name is Bonifacio Aleman. I am a Kentuckian. I am a member of my community, an active parent, a social worker, having earned an undergraduate and graduate degree in social work, and am currently working on my doctor of social work, all since my release from incarceration. I'm a community organizer working within the trust of communities across the Commonwealth. I'm a registered lobbyist with the Kentucky Legislative Review Commission in my capacity as a staff organizer for an organization where we help shape public policies that serve the interests of the communities in Kentucky. I've led multiple public policy campaigns that resulted in community change, all since my release from incarceration. I've worked hard to give back to Kentucky, to give back to my community, and to help improve the lives of my fellow Kentuckians through our political system. It is through this work that I've been able to see firsthand that every vote does count. But long after completing my sentence and changing my life, I am still unable to access the most vital tool to make my voice heard and to help determine who represents me in government, and that is the right to vote. When I applied to have my voting rights restored, it was confusing, and my application is still pending. Right now, my fellow Kentuckians who apply to have their rights restored have no way of knowing whether they will be approved or denied because there is not an objective set of criteria in place. As you heard John say, there's not even a specified time limit for when we can expect to hear. I'm at the 2-year mark. We should not have to rely on the goodwill of a governor or any other elected official when it comes to being allowed a full place in the democratic process. Democracy should be unfettered. We need a clear path forward for people like myself who want to participate as returning citizens. I believe I deserve the right to vote, and I believe that all Kentuckians should have that same right and the opportunity to be part of a healthy, unrestricted democracy. Thank you.
Thanks very much, Bonifacio. Bonifacio has been with us on this case for 5 years, and we continue to fight, and we'll keep fighting for the right to a fair and non-arbitrary rights restoration system until we succeed. With that, we'll transition to our Q&A portion of the discussion. Due to the ongoing legal proceedings, all questions should be directed to me, but we will, we can set up separate interviews with Bonifacio, as well as with the other petitioner in the proceedings, Robert Langdon. Please feel free to submit your questions into the Q&A box below. I'll read out the questions that come in for us and our speakers to provide responses. We might not be able to get to everyone's questions, but we'll fit in as many as we can. So one is, how does the rights restoration system in Kentucky compare to that in other states, i.e. in Virginia, where Governor Youngkin implemented a similar system? So as we said before, 40 states in the country plus DC have non-discretionary restoration of the right to vote. I'm rarely in the position as a voting rights lawyer of saying, please do what Texas and Georgia do, but that applies here. It's the rare case where I can say, please just do what Texas and Georgia do. They restore the right to vote at a fixed moment in time. If you complete your period of incarceration and parole and probation, you get your right to vote back. No applying for the blessing of a government official. In Virginia, Virginia was one of the success stories. Virginia, for the last 9.5 years, moved towards a non-discretionary system where the right to vote was restored at a fixed moment in time upon completion of the sentence. And even under the last Governor Ralph Northam, it was automatic. There was no application process for about 69,000 people. Something like over 350,000 people were restored in Virginia. But Governor Youngkin has rolled all of that back. He's erased a decade of progress. And we've sued, my organization, Fair Election Center, has sued. We have a pending case at a much earlier stage in district court that has survived the motion to dismiss and is now in discovery, heading towards a summary judgment motion deadline in the new year. So that's much earlier days, but we've survived the motion to dismiss, so it shows that there's some traction for this argument under the First Amendment. The system is, different only in the details. It is an arbitrary licensing system where someone applies to the governor reviews their file and decides, with no rules, no criteria in place, whether to restore that person's right to vote or not. So we've brought the same two First Amendment claims in both Kentucky and Virginia. The cases are just in very different stages, where Virginia was filed just this year, and the Kentucky case is now at the U.S. Supreme Court on the cert petition. Another question: in 2019, Governor Beshear restored voting rights for people with prior convictions who have completed their terms of incarceration, probation, and parole, which is estimated to be more than 100,000 citizens. Why is that not sufficient? When this executive order was issued, it was actually issued 2 days after Governor Beshear took office in December 2019. When it was issued, about 100, and numbers vary, the estimates vary, but something like 125, 130,000 people were restored to their voting rights. But it had no effect on people with federal convictions. It had no effect on people with out-of-state convictions, such as Bonifacio. And for that reason, an estimated 100,000 plus people are still left out in the cold by Governor Beshear's executive order. Right, this is what I was talking about before. This is the difference between the Kentucky order and his Republican counterpart over in Iowa, Kim Reynolds. Governor Kim Reynolds issued an executive order that only excluded the most serious offenses: murder, treason, etc. Everyone else, regardless of the jurisdiction, whether it was federal or state, was restored to their voting rights if they had completed their sentence. And that has held in place for since 2020, when it was issued. And no one has sued in Iowa. We've sued in Kentucky because Governor Beshear's executive order from 2019 split the disenfranchised population in two and created this two-track process whereby about 100,000 plus people were immediately restored to their voting rights, and over 100,000 people were still denied their voting rights and forced to apply for Governor Beshear's discretionary restoration of the right to vote. And that we see as an ongoing First Amendment violation. The district court actually, when that executive order was adopted, when it was issued, dismissed our case the first time for deeming it was moot, said it was moot. And we took that ruling to the Sixth Circuit and got a 3-0 unanimous reversal on that point. It was remanded back to the district court, and then the second time it was dismissed again, this time for lack of standing to sue. This time the court said it's not a licensing system, it's rights restoration, it's clemency, but it's not licensing. And we've taken that up on appeal to the Sixth Circuit and now to the U.S. Supreme Court. If the Supreme Court rules on this case, can you talk about the implications of the ruling the ruling would have on other disenfranchisement cases in states like Mississippi and Tennessee. Well, I'm not going to speak to specific states because we haven't focused on Mississippi and Tennessee. We've focused on Florida, Kentucky, and Virginia. But I'll say this. Anywhere in the country, if the Supreme Court were to rule in our favor on the merits, if they were first to hear the case, they have to grant the cert petition. If they grant the cert petition and hear the case on the merits, if they were to rule in petitioner's favor here, this would invalidate and strike down arbitrary voting rights restoration wherever it occurs in the country. Right? This particular circumstance is the governor restoring the right to vote on an arbitrary, discretionary and arbitrary basis. It's not impossible that the court could limit it to executive restoration, gubernatorial restoration of the right to vote. But we would hope for a broad ruling that would strike down arbitrary rights restoration in whatever form it takes throughout the country. But we are focused in this case on Kentucky and getting a ruling for Kentucky and the 100,000 plus people who still must apply to one politician to regain their right to vote. Let me just check quickly and see if we have any other audience questions. Not seeing any at the moment, but if anyone wants to add quickly. All right, short and sweet. So this fight goes on. We are now at the U.S. Supreme Court, and going to wait and see if the court grants the cert petition, and we'll hear the case on the merits. But one day, we truly believe that arbitrary voting rights restoration is so clearly unconstitutional, so clearly a violation of the First Amendment prohibition on licensing arbitrarily rights to political expression and expressive conduct, that we think one day it will fall. It's just a matter of time. So thank you very much for everyone's interest and for your participation in this conference and webinar. And we'll surely have more of these in the future if the court were to grant cert in this case. Thanks again for everyone's interest in this incredibly important issue and in this historic litigation. Thank you.